Well, the term of David Maraga as Chief Justice came to an assertive end last Friday, with the CJ living up to his reputation as a fierce defender of the independence of the judiciary to the very last minute. And as if to put pen to the reputation one more time, CJ Maraga formally wrote to pass the leadership baton, albeit in acting capacity, to his deputy Philomena Mwilu. Maraga's letter, something of a contempt card for all efforts, some of them in the form of petitions in court to stop Philomena Mwilu from assuming the role of acting Chief Justice. Well, on Newsnight, we walk the full breadth of the events at the top levels of the judiciary, including that one last fire exchange between the President of the Supreme Court, David Maraga, and the President of the Republic of Kenya, Uhuru Kenyatta. The two differed on a subject we are delving into tonight, that is the contentious proposal to appoint an ombudsman for the judiciary. Now, to help us through that panel discussion, live here in studio is petitioner Okiya Omtata, who wanted acting CJ Mwilu stopped from assuming office. He'll tell us why. Julie Soweto, who coincidentally is the counsel for Philomena Mwilu in a case, and of course lawyer Steve Ogola, and they'll be giving us tonight their legal thoughts on this. And that discussion is what we want to get into at this time. Remember, 22422 is the SMS line, and the hashtag is Newsnight. I think it's only fair I start with Okiya, part of the reason why we're here tonight, to tell us why he's back in court challenging the legality of Philomena Mwilu acting as Chief Justice. On what grounds, Okiya, did you move to court with?
Well, first of all, I would say that we should not even have gotten here, because if we have the experience of the Auditor General, where we had an issue whereby could somebody act as an Auditor General, and the court said no. It's a constitutional office. There's no mechanism for somebody to act in it. And so the best that should have happened is that Chief Justice Maraga should be leaving office with his successor already appointed, so we don't have the issue of an acting Chief Justice. It does not exist anywhere in law. Just like we don't have an acting Auditor General, it does not exist. And where the Constitution requires somebody to act, it states so. We have the President. The Deputy President can act in the absence of the President. You have the Deputy Governor. You have the Governor. The Deputy Governor can act in the absence of a substantive governor. But all these other offices do not have that kind of mechanism, and so there's no provision for an acting Chief Justice. So
your issue is not with Mwilu's woes, in court. Your issue is with the law and, your interpretation of it, that there is no way in which you could have an acting Chief Justice, whilst those who, quote the Judicial Service Act, Section 5 on the functions of the Chief Justice do foresee situations where a Chief Justice might not be able to act.
Even in the case of the Auditor General, the Act of Parliament had created the institution of a Chief Justice, of an acting Auditor General. But the courts were moved, and the courts agreed that for these offices, you cannot act in them. Only substantive office holders can hold them, because the kind of mandate they execute cannot be executed by an acting person. You must be fully appointed. So that's the main issue. And so Chief Justice Maraga's letter, with due respect to him, is basically a piece of paper. That's what I'm saying. I'm not saying anything beyond that.
Let me get a reaction from the advocate right next to you, Julie Soweto, on her views on this. Actually, let's begin with a quick reaction to that petition. I'm sure you've had a chance to look at it. What are your thoughts? What's your legal opinion on this?
Well, Okiya Omtata is one of my good friends, and he has done well in terms of fighting for justice, fighting for the rule of law. I think even the Law Society should recognize him as an honorary member. But even Okiya Omtata gets things wrong sometimes.
Many times.
And on this particular one, he has gotten it very wrong.
Why so?
The Constitution already envisaged such a situation as this and made provision for it. the office of the Deputy Chief Justice is not just a statutory one, it's a substantive constitutional office. The Constitution provides that the Chief Justice is the head of the judiciary, and then in the same provision also says the Deputy Chief Justice is the deputy head of the judiciary. So the Constitution envisaged that we will not have a vacuum in the office of the Chief Justice. We go through an elaborate process to appoint a Deputy Chief Justice, similar to the appointment of a Chief Justice. Surely it cannot have been that we vet, interview, take them through the ringer, only so that they can be there as a flower or as a poster. To do nothing, that is not the intention of the law. Now, the Judicial Service Act, Section 5, clearly provides, and it is a creature of the Constitution, which states that Parliament shall create the Judicial Service Commission, Judicial Service Act, to guide the functions. Not everything is spelt out in the Constitution. The Constitution gives the broad framework, and then legislation such as the Judicial Service Act provide for the nitty-gritty. And the Judicial Service Act clearly states that in the event of the removal, resignation, or the death of the Chief Justice, the Deputy Chief Justice will act in the place of the Chief Justice.
Sometimes when our viewers listen to Legal Minds on this show, they can end up a bit more confused than when the show started. I hope this won't be that kind of show. We've heard from Okia, Julie, Steve.
I think
help us make
right.
Okay,
Julie is right on the law. I hear Okia's concerns, but the reading of the law, the Constitution, the Judicial Service Act, and the Schedule 2, Section 5, Paragraph 5, all amplify the fact that in the absence of the Chief Justice, either temporarily or maybe upon retirement or removal, the Deputy Chief Justice shall assume those functions. So Okia's petition may have been misplaced to that extent. However, he raises public interest questions of management and transition, which may not be keyword within this petition, but things that are worthy pondering about as a country. Because the idea of the DCJ acting in place of the CJ upon retirement or maybe removal from office, although anticipated by the Constitution, but they should be in extreme circumstances. Right? So there was merit in the proposal to commence early recruitment of the CJ, so that we do not have public-spirited citizens like Okia Mtata questioning the rationale of the Deputy Chief Justice acting what he considers as substantively. But I think that is what the law says. She can act within the law.
Okay, and we'll be looking at some of your feedback. I know we have some tweets. We can put some of those up as soon as we have them ready. Remember, you can use the hashtag Newsnight. The SMS line is 22422. Okay, you've heard what your learned friends have had to say in response to that. One would then ask, and we've seen you doing quite a lot of public litigation, what do you say about the perception that you are a gun for hire? That on a day like today, for example, are you acting in public interest? Are you acting for unknown faces? How do you respond to those who have those questions about your style?
The Son of Man answered that question.
Talk about Jesus Christ?
Yes. He said, John the Baptist came and did not eat or drink. You called him a madman. I come, I eat and drink, you call me a glutton. So perceptions belong to those who perceive. They don't affect me. Back to the issue on the table. If you look at Section 5 that Land Council have quoted, they refer to very specific instances. Death. I don't know if you have a copy of the...
I have it here. Removal.
Yeah, just read it.
Resignation. In the event of the removal, resignation, or death.
Has Maraga died?
No.
Has he been removed?
No.
Has he resigned?
No.
Then what are we talking about?
No, go down and read paragraph 5. I think. You
So
have to
you
read
see,
it
paragraph
in
5 is hangs on paragraph 4. That those are the situations that are anticipated. This situation whereby somebody's time expires. Even if you go to the Constitution itself, the deputy president, even when, like right now, even where President Uhuru is vacating office at the end of his 5-year term, the deputy president is not anticipated to act in that office. We are going to have elections well before. And then on the day of that election, we shall elect a president, and there will be a transition to the new president. And Uhuru will stay in office and hand over to the new president. His term does not end on the day of the election, unlike the MPs. If you go to the government, so the issue of an acting constitutional office holder is in very, very rare circumstances. It's not automatic. So even for the deputy president, it's only in the situations where there is that death, where there is that removal, and where there is a resignation. It's not where somebody has served his term.
And yet, and when Julie was speaking,
having,
she actually referred to the same section of the JSC Act. Do you see where he's coming from? That if it doesn't fit that mandate, removal, resignation, or death, he doesn't then see how someone would act in the Chief Justice's position? Let me give you a chance to respond to that.
Now, and which is why, again, I said on this, Umtata is seriously wrong. The interpretation of the law is not supposed to be so rigid or so narrow. It provides for situations, and not everything can be written into the law. Now, is this a similar situation to the ones that have already been stated? Because this is a question now of interpretation. And it's in the same spirit, because the spirit of the law right now is that there should not be a vacuum in the office of the Chief Justice. It has made provision for one instance. This is a similar instance. And therefore, it applies. To mechanically apply the law the way Umtata is suggesting would lead to an absurdity, which again, the law abhors. So the bigger principle or the question is, should we suffer a vacuum in the office of the Chief Justice because the Judicial Service Act does not actually state? It provides for those situations, very similar situations that the law has taken care of. In any case, if we go back again to the very design and architecture of the Constitution, the Deputy Chief Justice deputizes the Chief Justice. She carries out the functions of the head of the judiciary. So if in one situation the law can actually see her acting as the Chief Justice, this situation is no different. It's already been taken care of. We do not need to create a problem where there is none.
Okay, noted. Ogola, you wanted to jump in even
maybe
well.
Before the Land Council comes in, this is not the first time we are having this situation. When CJ Mutunga left office, who acted? Who was the acting Chief Justice when Mutunga left office?
Does that indicate that it was the right or wrong thing? Because past precedence isn't always an indication that this was the right thing to do.
There was an
so are you saying that because it happened then?
No, I'm not saying because it happened. I'm just saying that it's not the first time it's happening. This issue came up, and it was agreed we could not have an acting Chief Justice.
It was agreed?
It was she's asking you. It was agreed?
Yes, because they never ended up appointing an acting Chief Justice. So the issue is not new. So the issue, and then number two.
Please keep it on number two. I need to allow Steve to come in. Number two. Yeah.
I thought you were asking me to knee.
No, I wanted you to finish with number two.
The number two I'm bringing in is that we are not saying that the law is we are being rigid or not.
Or too mechanical.
The issue is not being mechanical. Either we have the law or we don't have it. And our constitution is very prescriptive. It's a very prescriptive document. And if you just look at the architecture where it allows for acting in constitutional offices, you'll find that the office of the Chief Justice is not one of them.
Ogola, come in. I want you to respond to that because I want us to broaden the discussion.
And I think there's a huge knowledge gap between what the law says in totality and what Okia is saying. What Okia would do in these circumstances is to accept this advice as binding. It's coming from lawyers, the people that you would seek legal opinion from if he's stuck in his petition. I don't think.
I think Mr. Ogola, don't be so condescending. I think just talk. The law applies to everybody.
Thank you. I gave you a chance to speak, Okia.
You are not going to begin lawyering me here.
Okay. But he still has a right to have his...
Yes, but you should not condescend towards me. Let him just talk.
Okay.
Do not patronize me. If I need his opinion, I will seek it.
Fine, fair enough. He's made his point. You've heard it. Stop there. Carry on, Steve.
Now, I'm saying Okia is mistaken, and he's making an innocent mistake because he's not a lawyer. His claim that the Deputy Chief Justice cannot act in the absence of the Chief Justice is totally misplaced, but is also forgivable because lack of training and understanding on the proper interpretation and application of the law. We are advising, okay, we can't have this conversation where there's a back and forth between Okia Mtata, who is a non-lawyer and is not trained in interpretation of the law, and lawyers. I mean, I'd appreciate if my senior Julius were to post it differently, because then we would be looking at how do we interpret the law. There's consensus here that the Deputy Chief Justice may act in the absence of the Chief Justice, and we can't belabor that. I think, okay, I just accept that advice as binding, and the court will tell you so. But we appreciate, there's a point he's making which we appreciate. I think in terms of good governance and in the spirit of continuity and smooth transition, and that is where I see Okia's coming from, there is a genuine concern that if we know that the CJ is going to retire, there is no harm in commencing the replacement early enough so that transition is not interrupted. But should we find ourselves where we have to commence replacement of the Chief Justice upon retirement, there is no vacuum. Now, you can debate with that, so I think that is just settled as it were.
Let me ask you this, Steve. Why is there so much hullabaloo of who will act? I mean, for goodness sakes, it's just an acting position. Why should it be a big deal? Why should JSC, Okia, and others be so concerned about who will act or who won't act in the absence of Maraga?
The reason why acting is very important, because you see, the Deputy Chief Justice, which is now the second most senior judicial officer in the country, may want to succeed CJ Maraga, and acting as the Chief Justice, she'll be the person gazetting the vacancy by law established. She'll be putting in application. She may not be sitting in that subcommittee that will be considering it, but there's some political and other dividends that she may get by acting as the Chief Justice during the transition period. And I think there's a serious constitutional concern. So, see, the most important question of constitutional relevance is, to what extent does an acting DCJ stand to benefit, even if it's some of perception, when you're recruiting a CJ? You get? Mm-hmm. I think that concern is also legitimate. So that is where the tension is coming from. Otherwise, acting for about 6 months, a maximum of 6 months, as we get this, the substantive office holder, does not offend the Constitution or any written law.
Fair point there. Okay, I know you have a lot you want to get off your chest. I'm coming to you shortly. I'm told we have some tweets. And remember, you can weigh in on this using the SMS line 22422. This is what some of your thoughts are tonight. Let's have the first one up. All right. Engineer Lazaro says judiciary should be left alone to conduct its functions independently without interference from the executive. Okay, in brackets, deep state. Lazaro, you seem very clear that there is that interference. Ephantas Mutiga says, it's my prayer that JSC will give us a sober, candid, courageous, articulate CJ to fit in the shoes of David Maraga. Okay, that's Ephantas Mutiga there. Koech Kip Courier says, ask Wakili, okay, I have at least 2 here in studio, so I'm not sure which one, if the best international practice for DCJ to act in capacity of CJ and Deputy Attorney General to act in equal measure. Okay, I hope you've noted that to my guests here in studio. Edwin Nyakweba says the government arms ought to work as a system. They are interdependent. Kenya needs a CJ who is not a sympathizer of political divides. One is ready to build on jurisprudence. But before anything else, the judiciary needs adequate funding. Okay, and I'm told we have one more. Kanyi Tetu says, I had not reflected on the issue of constitutionalism of having an acting Chief Justice. The Constitution must, however, work for the people. If at all there is no personality or moral barriers for her to take over. Okay. I'm told we have one more. David Makali, very interesting discussion on Citizen TV on Maraga's delegation of authority to DCJ Mwilu to act as substantive Chief Justice. Is it ultra-virus the Constitution? Moot point raised by Mtata petition. Should DCJ just have transitioned without delegation? Edgy conversation. Indeed, Makali, edgy conversation. Okia has reached out for a copy of the Kenyan Constitution. I don't know what he wants to share with us at this moment. Even as Okia, you ponder on this question by Ogola here. To what extent would an acting DCJ stand to benefit by acting as Chief Justice, even if it's for under a 6-month period?
I think
is that one of your concerns?
That's not my concern, that anybody would benefit or not, because I know that the process of appointing the Chief Justice, if at all it is as it is on paper and not flexible the way my sister would like us to believe that you can, it's like plasticine. If it's rigid on paper, I wouldn't be concerned with anybody acting. What I'm saying is now, like you see, where does Maraga get the power to appoint somebody to act? If it was automatic, as they say, then why did Maraga write the letter? If it was automatic, why would he write the letter? You see. So the issue is that, according to, first of all, if you look at the text itself of the Constitution, the Chief Justice acts, the Deputy Chief Justice acts under the direction of the Chief Justice. Okay? So, where there's no Chief Justice, there's nobody to direct her. She can, her or him, he cannot then come and say that he's acting in this position because he needs to be directed. Secondly, there's no vacuum. No vacuum is being created. The High Court has its principal judge. The Labour Court has its principal judge. The Environment Court has. The Court of Appeal has its president. The Deputy CJ is there as the principal judge of the in charge of the senior most judge in the Supreme Court. The Chief Justice then, the absence of the Chief Justice does not create that vacuum that we are trying to anticipate. And this is a self-inflicted crisis, whereby we know very well Justice Maraga will be leaving office on such and such a day. The Constitution does not anticipate an acting Chief Justice.
Who takes over in the leadership of the JSC, at least for the time being?
The JSC has got a deputy chair. But the Chief Justice, I was coming to the issue of the Chief Justice acting, an acting Chief Justice.
You want us to just really, narrow in on that?
There is no provision for acting in that office. It's an office that can only be occupied on the substantive terms. So to say that the deputy is going to act, I would ask in which text do they act? And that's what I'm saying, even if you look at my petition, I've even challenged the constitutionality of Section 5.
Yes.
Saying that section of the Act is unconstitutional by creating the office of an acting Chief Justice.
With so much happening in this country, Okia, why this issue in particular? Why this? And I know you go to court quite often.
But I've taken out, which other issue have I left out? Give an example. Which one have I not taken out?
Because some say that there could be politics behind this, that when you see Okia moving to court, when you see so much acrimony over the simple matter of who will be acting for the Chief Justice.
Follow the evidence before.
Where there's smoke, there's fire.
Nowadays, you can have a machine creating smoke. You don't have to have fire. You can have artificial smoke. So what you do is follow the evidence.
Perhaps, Waiga, we need to learn from history, because history is a good teacher, the rear view mirror of history. One of the things, when former Chief Justice Ivan Gisharu was leaving office, before Chief Justice Willie Mutunga was appointed, there was a vacuum for about 4 months. Now, during that period, from what I gathered, because there was no one in the office, people took advantage. One of the things that suffered was the vetting process. It didn't yield as well as it was supposed to yield, because in the vacuum period, in the 4 months, judges, judicial officers went and cleaned their files, worked on their files, because there was nobody in the office. And that is the kind of vacuum that the Constitution has taken care of, and which we do not want. That's just history. We learn from it. And again, that's why we're saying that even when the matter like this goes to court, we interpret and look at it purposively, fully. What is it that the Constitution or the framers of the Constitution were looking to correct? What is the mischief that was sought to be dealt with? Because otherwise, what's the point of having a Deputy Chief Justice? What is the role of the Deputy Chief Justice in the Constitution? We don't just start from the Judicial Service Act, which is why I say that Okiya Omtata's position is too narrow. You have to go to the beginning. The Constitution has provided for a substantive office of a Deputy Chief Justice. It is not cosmetic.
Did the writers of for example, the JSC Act make a mistake in leaving out, one more sentence that would have said, should the Chief Justice be on leave, for example, that automatically the Deputy Chief Justice takes over? Could that sort all this and simplify this discussion for us?
But the law is as it stands right now. We're positivists. What the law states right now is what we take it to be. Now, again, the argument made by Omtata that, what was that he said?
As long as it's not explicitly written, in the law, or is that what you're referring to?
Yeah, no, actually what he said was that the Chief Justice, current Chief Justice Maraga, by writing a letter handing over, has somehow violated the provision of the Act. Just because he's done a superfluous, he need not have written the letter. But then again, cautious people, just so that there is no doubt, for the avoidance of any doubt, again, perhaps for my colleague Omtata, he spelt it out, said, I hand over, I am leaving office. There is nothing wrong with that. You can wear your suspenders and a belt. You don't need both, but you can have them. It does not invalidate the other. It does not invalidate the fact that the Deputy Chief Justice is by law entitled to act in the position of the Chief Justice when there is no Chief Justice.
Ogola, tell us this. Should the courts disagree with Okiya and allow the Deputy Chief Justice to keep acting in that position, what can she and what can't she do?
Well, I think she may not perform substantive functions of the Chief Justice, but really, when you're acting as the Deputy, as the Chief Justice, there are a lot of administrative functions that she may perform, and they're outlined in the Judicial Service Act. She has actually been performing some of those functions, representing and deputizing the Chief Justice. That's why I'm saying that this is not really an issue that ought to have received a lot of scrutiny, but what I try to reframe, and Okiya has disassociated himself from that issue, is that there was a public interest concern that we need to do better in terms of managing transitions. But should we fail to manage transition better, that is why the law exists. So there's really not much of a crisis. The DCJ will continue to speak for the judiciary, for instance. She will continue to perform functions like representing, the judiciary in engaging with other branches of government, for instance, the executive and the legislature, parliament, if there's that opportunity. She will continue to, she could transfer judges, because the transfer of judicial officers is a core function of the CJ. There are some functions that she can perform during the interim period that are not necessarily do not necessarily take over the core functions of a substantive office holder. In the interim period, since the main issue now we are going to move into upon retirement of the CJ is the recruitment, I think there will be little activity, because if it is judicial resolution of disputes, we don't need the Deputy Chief Justice or the Chief Justice directing how courts resolve matters pending before them. These are largely administrative functions, and they have been outlined in the Judicial Service Act. So there's really not much to worry about. You know, I think the more important question of constitutional relevance, we can really say this, the posturing for succession of Maraga's position receives a major boost if the DCJ is acting as the CJ, especially if she's going to put in her application. We don't know that just yet. But being the acting CJ, obviously is a leap ahead of the rest.
Some would ask, is the issue then that Deputy Chief Justice will act in the position of a Chief Justice for 6 months? Or could there be some with an issue with the person herself, Philomena Mwilu? How much of what are you reading into this?
The optics, within the proper reading of the law, if you look at what the law outlines as the procedure for recruitment of the Chief Justice, those optics may not in reality really tilt the favor, really tilt the scales in her favor, but it serves to some moral comfort or moral and some dividend you get if you are acting as Chief Justice while also waiting to be confirmed, for instance. But as to the suitability of the DCJ Mwilu particularly to act as a CJ and also probably to assume that role in the future if that opportunity comes, I think there are genuine concerns that go into her integrity. I don't think the DCJ is fit to succeed Maraga.
That's your personal opinion, and her counsel.
Yes. I mean, it's opinion also that is also founded in the law. If you look at the procedure and the manner of appointment of persons to occupy the office of the Chief Justice, integrity is a central concern. And you remember the DCJ has dubious integrity credentials.
Questions.
Because, yes, very questions. Serious integrity.
We live in a country.
Yes, very serious integrity.
Innocent until proven guilty. No, I need to catch you on that. Innocent until proven guilty.
What I'm saying, let's not conflate the presumption of innocence until proven guilty is within the realm of the criminal justice system. Yeah, in the public law sector, when you're talking about appointment to key public offices or state offices, as the office of the Chief Justice, integrity could as well just be reduced to the question of questions emerging that are left unanswered about your suitability. You remember in 2018, I think around August 2018, the DCJ was arrested and charged. Among other issues, abuse of office. She is alleged to have written letters using the judicial letterhead to Imperial Bank. I think the evidence was expunged from the record because they were not accessed the right way. The legality or the validity or probity of that evidence was never really tested. But I think what the DPP did, and it's in the public domain, that a matter was referred, a petition for her seeking a removal was referred to the Judicial Service Commission, which is our employer, who incidentally will also be sitting to replace the Chief Justice. Those integrity questions will burden the Supreme Court if DCJ Mwilu were, for instance, to be appointed the CJ.
Okay.
Again, also in terms of optics, if you look at the way that case was managed, and she appointed political leaders, which I think was a serious error in judgment, in a very delicate and fragile court such as the Supreme Court, perception is everything. If you choose to go with the likes of Senior Counsel Kongo Mugeni, Senior Counsel James Orengo, when you have a pool of competent and capable lawyers like Billy Soweto,
that is her right.
That may alter the perception.
Fair enough. I'll stop you there because you're walking on dangerous territory, and I want to read some feedback here. Kipchumba Murkomen, Senator, saying, remind Omtata that DCJ Kalpana Rawal retired the same week with CJ Mutunga. Okay, I'll allow you to respond to that. Herman Manyora is saying this. Newsnight, ask the lawyers whether it is not possible for a CJ to give his deputy a head start by, for example, leaving him or her acting long enough to benefit from the temporary incumbency. Okia Omtata is right. That's what Herman Manyora says. That's what he's tweeted. And let me read 2 SMSs. Kenyans are really interested in this discussion. Someone, you don't tell us your name, where you're writing from. You're asking who will hand over to the new CJ. Maraga, or the acting Chief Justice, okay. Orondo Tuli says, the DCJ may act, but the outgoing CJ cannot appoint. It's the JSC to make the appointment, isn't it? Those are some questions. Okay, let me start with you. You could respond to what Kipchumba has sent in.
Kipchumba is a lawyer, and I think he has read that last part of Section 5 of the Act. It says, where both the CJ and the DCJ are absent, the senior most judge of the Supreme Court acts as the CJ. Why did it happen under Mutunga?
Why didn't it happen?
Yes. Well, yet the law said that the senior most judge could have acted. So what Murkomen is raising is not really here or there.
But failure to follow the law does not...
No, I'm not saying failure. I asked him a question.
Okay.
That the reason why nobody acted is because both Mutunga, because Rawal went out in that petition which I participated in, and Mutunga, incidentally, when he passed, the last judgment decision he made was the one determining the fate of Rawal, and he left the scene. So both of them were out of the job. But Murkomen's concern is not trying to contradict my position, does not arise, because the same law provides that the senior most judge of the Supreme Court acts as the Chief Justice. So then I would throw back to Murkomen and say, why didn't the senior most judge of the Supreme Court
at that time
act as the Chief Justice? So the question still remains that nobody can act as a Chief Justice. Because the position of acting Chief Justice is not there. The position of acting President is there in the Constitution. The position of acting Governor is there in the Constitution. The position of an acting Chief Justice is not there. And so we cannot just create it by statute.
Let me ask you this to help us take this discussion forward. Clearly, the Maraga succession will be, for lack of a better word, there's a lot at stake in this. And for someone who visits the courts almost every other day, what sort of Chief Justice, what are the qualities of the next Chief Justice that you would desire to see? First of all, for you who really is involved in a lot of public litigation as Okiya Omtata, what qualities would you want to see?
I think I'll just see what the law requires.
That's a very vague answer.
No, they are there.
You must have preferences.
The requirements are there. And I think that, to me, a Chief Justice has got the courage of his convictions and who understands the law. He's the man we want in that position or the woman we want in that position. I don't think I've got any preference for whatever, because sometimes, and I must confess that even when Justice Maraga took over, I'm among the people who did not think very highly of him, because he is a man who distinguished himself by cruising the middle. He existed at times of very great civil strife in this country. He never stuck out his neck for anything. So, much as his performance has not been stellar, he has performed beyond my expectations. And on my scale, I would give him a 6 out of 10. So it surprised me, because I expected to give him a 3 when he came in. But he surprised me that he was able to do something, although he wavered here and there, occasionally he wavered. But when the rubber hit the road, I think he stood tall.
And you have and as you look forward to the challenges the country will face in the future, you don't want to give specifics on what you'd want to see?
I would like a person an individual who has convictions and the courage of those convictions.
Okay.
That's what I would expect.
That's what you'd expect to see. Julie, come in. I know you'd want to respond to maybe what Steve said.
And of course, he'll be given the minimum eligibility requirements. A land council, they need not be worried, because a man like Omtata does not qualify. So you need not be worried that a lawyer will get there.
Okay, fair point. Let me give Julie a chance to come in on this as well, and also tell us what her wish list would be for the next Chief Justice.
I think the considerations for the next Chief Justice should be informed by, again, what has been happening in the past. Since Chief Justice Mutunga was in office, followed by Chief Justice David Maraga, there has been a lot of interference, an attempt to undermine the independence of the judiciary. It is therefore evident that the executive and the political class has a great interest in the role that the judiciary plays, and so they would want to cut the legs of the judiciary, undermine its independence, so that it doesn't function the way it's supposed to function. And so for me, what I would want to see in the next Chief Justice is a person who is fiercely independent, who owes no favors to anybody, especially the executive. We do not need an appendage of the executive as the head of the judiciary. History should just teach us that. And that is exactly what all this posturing is about.
Your client has faced her fair share of woes over the last year and a half or so. Some link it with possibly the nullification of that presidential election in 2017. Do you hold the same view?
Well, I think those who have eyes to see, let them see.
Okay, you're very short. To the Ogola, come in as well. What's your take on?
I think the next Chief Justice, the question that we may have to ponder when you are replacing CJ Maraga, who has done an excellent job in very difficult political and toxic circumstance or environment, should the next Chief Justice have a known legal philosophy or not? Should he be a liberal or should he be a conservative judge? I think these are the questions that the JSC must grapple with, because we saw that CJ Maraga nullified the outcome of presidential election. Can the next Chief Justice, reading the law purposively and finding that circumstances do in fact exist, and my learned senior Julie has litigated at the Supreme Court on these matters of presidential election petitions, can the next Chief Justice should truly have the courage and conviction to nullify the presidential election petition outcome? I think, observing the political context in which you operate, although the Constitution anticipates scenarios that if exist, the outcome of an election may be nullified, I can dare hazard that the JSC is likely to go with a conservative judge who will not disrupt the process of democratic maturation of our electoral processes and systems. We are likely to get a more conservative Chief Justice who will not disrupt the status quo, because we have seen that there's been the twin problem that when judges animate the independence as anticipated and expected by the Constitution, the backlash has been immediate. And all of us know that. I think the question about defunding, delegitimizing, defanging the judiciary, these are issues that are well established in the last 3 years. We've seen that. Also, the court will have to think, if we nullify the presidential election, in terms of legal philosophy, does this country have the capacity to respond to a fresh election that can be conducted substantially in compliance with the Constitution and election laws? I don't think we are ready yet. So I would suggest that it seems to me, understanding the political terrain and the election laws and the Constitution in totality, we are more likely to produce a more conservative Chief Justice than a liberal.
That's your prediction?
Yes. Looking at the history of democratic maturation of our institutions and political maturation, the judiciary has been demoralized because they've been attacked very viciously by the people, the institutions they sought to protect. The integrity of the electoral process, the purity of the process, and the offices created under the Constitution, they have paid the heavy price. You've seen the CJ Maraga saying in his last comments that the infrastructural development that we've seen the judiciary has done is largely donor-driven. Why should an institution created by the Constitution, a co-equal arm of government, be donor-funded? That is something that the next CJ must worry about. So I think there are many lenses to look at it. The question about the suitability of some of these kinds of, the reason why scrutiny is on the DCJ, because now she's acting lawfully, permitted by the Constitution, contrary to other beliefs. She's the only person who is thought to be ahead of the pack right now because she's the most senior most judge, she's DCJ, she's likely to express interest. And scrutiny will be on her, understandably, and I think that pressure is also welcome.
Okay. Okia, you asked a question here about who acted for Mutunga when he left, and he left quite early, I think almost a year.
Yeah.
You want to respond to that?
You know, we forget that when Mutunga left, there was no Deputy Chief Justice because Justice Kalpana Rawal also left at the same time. But Mutunga actually appointed Justice Ibrahim and left him in charge. There was no vacuum.
Ibrahim never served as an acting Chief Justice.
Okay, because I have the release where Mutunga, making his final address, it was on a Thursday afternoon. He stated that Justice Mohammed Ibrahim would act as Supreme Court President and would administer matters of the Supreme Court. That is the...
Not the Chief Justice.
Sorry, say that again.
He never left him as the Chief Justice.
It's the same thing.
The Chief Justice is a bigger office than the President of the Supreme Court.
Okay,
That's why he's the Chief Justice of the Republic of Kenya and the President of the Supreme Court. Just like the President of Kenya, he's also the Commander-in-Chief of the Armed Forces. So you cannot say President Uhuru Kenyatta is simply a Commander-in-Chief of the Armed Forces. He's not. He's also the President of the Republic of Kenya. So the Chief Justice is both the Chief Justice of the Republic of Kenya and the President of the Supreme Court.
Okay, I'm struggling to
and
understand
so Ibrahim,
your argument there.
Mutunga left Ibrahim to be the President of the Supreme Court, which Justice Mwilu can act as, but not as the Chief Justice. That's the distinction.
Okay,
we know we're going to lose our train of thought because there are some matters that we run out the risk of repetition.
Briefly, because I have one last question I need to get from all of you away from this. Yes.
The thing is this. There's a point, even though OK is not recognized, but it's very legitimate. I think going forward, we need to agonize and organize very quickly how the replacement of an outgoing Chief Justice can be done in time.
Okay.
So that we don't have to raise this. Okia's questions are legitimate, even if you're saying that they're not really properly anchored in the law, but it doesn't take away that as a public-spirited citizen, he's raising questions that many may also raise. And I said, if you reframe the question, does that give the DCJ a head start? Of course, yes. Does it matter then? Of course it does matter. Should we then do things differently? Of course, yes. So I think that is how we can settle the matter concerning the position in the law, whether the DCJ can act or not.
Okay, let's move this forward with one last question before I read feedback. I'm seeing a lot of it.
I needed to make a declaration.
Which will force everyone to respond briefly, please.
No, not to respond.
Okay.
At the beginning, is that Justice Mwilu, Deputy Chief Justice, is not a stranger to me. He's even my friend. She was even my landlord at one time. So, I'm not saying this out of hatred or this is somebody I know.
Okay.
Somebody I've talked to on phone, somebody I've shared SMSs with. Okay? But I'm saying that this is the law, and I'm a greater friend of the law than of an individual. So it's important to make that declaration.
The declaration is that it's not personal.
No, it's not personal.
Okay.
It's somebody known to me.
Then answer this question even as we finish this up. In your view, there has been a lot of talk about the BBI proposal on the Judiciary Ombudsman. This is where I want to finish hearing from each of you. And for you, Okia, someone who's done a lot of public litigation, some say you've played the role almost of an ombudsman of sorts, keeping various parties accountable. Maraga last week, we saw that him saying the proposal is a direct conflict and duplication of roles between the Ombudsman and Judicial Service Commission. The President, a couple of days later, Uhuru Kenyatta, faulting the judiciary, insisting that the judiciary's checks and balances can only be done fairly by an independent body. Let's start with you, Okia. What's your view on this? Does the BBI proposed Ombudsman bring justice closer to Kenyans and keep the judiciary accountable?
You're asking me a difficult question. Like, you want me to comment on the color of a building without commenting on the structural integrity of the building, so it becomes difficult for me to answer.
Okay. the structural integrity of the building will be affected. What the president here is saying is he is concerned about the integrity of the judiciary and who keeps the judiciary accountable. Does that not concern you as well? Maybe you could comment on that, not about the color.
I don't know, but to be open and frank with you, I've not commented on the merits of the BBI.
Okay.
And if I have to comment, I need to comment comprehensively on the entire document, not on one aspect of it.
We'll take that as your...
What I've commented on has been the process of the BBI, which is not what you have raised. So I cannot answer, but I think in terms of the judiciary and given the time when the proposal came up, I think Justice Maraga answered that question when he was still in office, before he went on terminal leave. He answered that question. Among the last things he did was to answer that question, and from where he sat, I think he felt that it would compromise the integrity of the judiciary if they were directly answerable to a supervisor or something like that.
Okay, let me get Julie's take on this. The ombudsman as proposed by the BBI, good for the judiciary or a chance for external interference in the matter of the judiciary?
Look, I like the idea of an ombudsman for parliament, an ombudsman for the executive. But when you see what has happened to, for instance, the Commission on Administrative Justice, you want to be a bit cautious. The judiciary already has an ombudsperson. In the past 9 years, there have been 3 Supreme Court judges who have faced a tribunal, another 4 High Court judges who have been sent to a tribunal. There have been scores of magistrates and judicial officers who've been dismissed or suspended. In a politically toxic context like we have in this country, you really want to be cautious not to overindulge politicians.
Ogola, when the president raises concerns about the accountability of the judiciary beyond where we are, and for someone who practices, before our courts every other day, do you also have concerns? Would you like to see more being done to check the judiciary? And is this ombudsman a step in that direction, in your view?
First of all, Avaiga, the proposed judiciary ombudsman in the current format signals a very dangerous turn for our judicial independence. It's a very subtle attempt, but it will gain momentum when you're clawing the independence of the judiciary, when you have a political appointee supervising the performance and initiating the removal of disciplinary procedures over judges that are supposed to be independent in their functions. But be it as it may, if the concerns are genuine, and the concerns should be genuine in terms of holding the judiciary accountable, the Constitution itself anticipates that the judiciary will be answerable to the people through their actions and to the JSC, to the people through JSC. So we already have a judiciary ombudsman in place. We could strengthen that office without weakening, without deferring that office to the political wing of government. There are also procedures for removal and disciplinary of judges within the Judicial Service Commission. We could strengthen them. Are there concerns that JSC is protecting senior judges or judges, for instance? If those concerns are merited on case by case, I do not believe that JSC is protecting judges and therefore unable to discipline or to remove them, because judges have been removed in merited cases. So I think there could be more harm than benefit to be derived from the appointment of judiciary ombudsman by the president. If there's an opportunity to shelve that, let us do so. I think if we don't shelve it and it passes within the Constitution of Kenya Amendment Bill 2020, there may be an opportunity to harmonize that provision within the Constitution so that we protect the overall integrity of our judiciary. We cannot allow the judiciary to be susceptible to external control or influence.
And that is where we're going to have to leave this discussion. The law, and where you have lawyers involved, we could have this discussion the whole evening, but let's take a look at some of your feedback. This is what Kenyans are saying. #Newsnight, SMS line 22422. I think let's start with the tweets. First one up, this one from Alex Owiti. Why did the constitutional architects not envisage such gaps whenever a CJ retires and have a DCJ to act? The issue needs to be resolved to avoid such standoffs when politics takes center stage. Thank you, Alex. I did actually ask that question. And another one here, this one coming in from Buvi Dan. The CJ is only on leave if we go by the terms. His term is yet to end. There is a timeline. In that space, what's the role of the DCJ? Someone here via SMS line 2242 says, our Constitution, Article 166 allows Chief Deputy Justice to act in office if there are no cases involving her. Okay, that's your interpretation. Someone here says, is Okia arguing because he knows how to read the law or because he knows how to interpret the law? Okay, that's Caleb from Pipeline. I'm not sure I fully understand your question. Let me see if there's one more SMS. Alex Shega says, in the absence of the chair, the deputy takes over. That's why there's a deputy in the first place. And one other person asking, okay, no, that's actually the same message. We're going to have to leave it at that. Some of the questions might border on sub judice, which we don't want to get too deep, we don't want to get into at this time. And so thank you so much to each of my guests. I know this is a discussion we're going to be having for the better part of the next couple of months with the exit of Chief Justice David Maraga last day, I believe, January 13th, and the process to, recruit a new Chief Justice happening as well. Thank you so much. We've had here Steve Agol, an advocate of the High Court, Julie Soweto, an advocate of the High Court as well, Okia Omtata, human rights activist, who has taken a petition to court challenging the legality of Philomena Mwilu acting as Chief Justice. And that's why we needed to have him in here for this discussion. Meanwhile, I know the discussion online as well is about that Msambweni by-election. These are the latest results that we have, provisional results. The independent candidate, Faisal Abdallah Bada, 2,910 votes. ODM's Omar Boga, 2,845 votes. And Mahmoud Abdul Rahman, Wiper candidate, 124 votes. Let me take that again. Faisal, 2,910. Omar Boga, 2,845. Sheikh, that should be Sheikh, I believe. Mahmoud Abdul Rahman, Wiper, 124. Hamisi Liganje, UGM, 32 votes. Marere wa Mwachai, NVP Party, 32 votes. Ali Hassan Mwakulonda from the PED, 57 votes. And another two independent candidates, that's Charles Bambo, 20 votes. Charlotte Akinyi, 2 votes. And Mansuri Abdul Rahman, 3 votes. Those are the results from 32 polling stations out of 129. Keep it Citizen TV into the night. Tomorrow morning as well, I know on Daybreak, we endeavor to give you those results as and when we get them. And we are getting them from our teams on the ground who are actually at that tallying center. I know there's a lot of confusion with some of the results that you're seeing online. Be careful what you forward and share. But right here at Citizen TV, we'll be giving you the results that we have verified. That's why we wrap up this discussion. Thanks for tuning in on this 15th day of December 2020. My name is Wahiga Mwaora, and our sign language interpreter has been Joki Shege. On behalf of the whole team that's made this broadcast possible, as always, we say thank you. Without you, this would not be possible. Have a good night. And as always, stay safe and keep it Citizen TV, where we'll give you updates on everything that's happening, including that Msambweni by-election when we get them. Good night.